Welcome to the Government of British Columbia's Employment Standards Branch. We are responsible for workplace standards, like hours of work, minimum wage, overtime, breaks, statutory holidays, and termination of employment in non-union workplaces. These standards are set out in the Employment Standards Act. This video shows how we resolve complaints under the Employment Standards Act. We receive about 7,000 complaints a year. We can help you resolve your complaint for free through the following steps. The first step is the Self-Help Kit. The kit is used by employees and employers to decide whether the Employment Standards Act applies, assess whether there is a contravention of the Act, and whether a complainant is owed money, and if so, how much. It also includes forms and letters that you can use to request payment from an employer. An employee must fill out the kit and send it directly to the employer. Once received, the employer has 15 days to respond. The Self-Help Kit is not required if the employer's business is closed, the matter involves a person under the age of 19, the employee is a farm worker, garment or textile worker, or a domestic, the employee has significant language difficulties, the complaint is related to a leave provision of the Act, the employee has already sent a letter to the employer attempting to resolve the issue. If an employer agrees with the employee's request, money can be paid directly to the employee to resolve the matter. If the employer does not agree with the employee's request, they should discuss the matter with the employee and try to resolve the problem. If the problem isn't resolved using the Self-Help Kit, or if the kit is not required, an employee may file a written complaint. Complaints must be submitted within 6 months of the last day of work, or if still employed, within 6 months of the alleged contravention. Once a complaint is received, we will try to help the employer and the employee resolve it by educating them on the Act. Last year, over 25% of complaints were resolved this way. Providing education is a good way for employers and employees to learn about the Act and how it applies. If a complaint is not resolved through education, it is usually set up for mediation. Mediation may sound complex, but it's actually an informal meeting between the employee and the employer, conducted by the Employment Standards Branch. If a complaint cannot be resolved through mediation, an adjudication hearing may be scheduled, or it may be assigned to an investigation. An adjudication hearing is a more formal way of resolving a complaint that involves the Employment Standards Branch making a binding decision called a determination. A determination will identify whether the Employment Standards Act has been contravened. If it has, the employer will receive a mandatory penalty. A determination is enforceable like a court judgment. If a complaint is assigned for investigation, an Employment Standards Branch officer will speak to both parties and gather evidence. If the officer cannot help the parties come to a voluntary resolution, the officer will issue a determination. Determinations may be appealed to the Employment Standards Tribunal, which is separate and independent from the Employment Standards Branch. The determination includes information on the appeal process. You can learn more about mediation and adjudication by visiting our website, watching our videos, or looking at our fact sheets. If you have questions, call us toll-free at 1-800-663-3316.